Good morning. Happy Sunday. A lot of idiots are in my comment section talking about how James should sue and what he should sue under and this and that and the other thing. And I figured instead of battling them one by one in the comment section, I would just make a video on what James is looking at if James decides to sue. Number one, first and foremost, is you have to figure out what kind of an action you would sue under. There has to be some sort of a statutory authority for you to sue. And in this case, well, I guess it's technically not a statutory authority, it's named after a lawsuit, but in this case, the authority that you would sue under would be Bivens. It's what's called a Bivens action. It's not a 1983 lawsuit. 1983 lawsuits are if a person violates your rights under the color of a state law or local law or District of Columbia law. Bivens actions come into play if someone violates your rights under a federal law. So that is the difference. There are some other minor variations too. And it doesn't matter the nature of the person who violated your rights under the law. A state police officer could theoretically violate your rights under a federal law if he arrests you for a federal crime and not a state crime. Could happen. Or a federal officer, if they arrest you under a state crime, they could be subject to a 1983 lawsuit. Could happen. But if a security guard is working for the federal government and he's arresting you for various violations of federal law on a federal base, you can rest assured it's going to be a Bivens action. Now, Bivens actions like 1983 lawsuits have Monell claims, but they're limited. Under a Monell claim in a 1983 lawsuit, you can say, well, the state, the city, whatever, has promulgated this particular rule, policy. They've trained the officers inadequately, so the city or state should be liable. They have that in Bivens actions, but it's much more limited. You can say like the supervisor in his individual kind of capacity has a Monell liability. Oh, hold on. All right, so you could say that the supervisor has a liability for something that the supervisor did, and you can get to the supervisor via a Monell claim, but you can't get to the agency. Federal agencies, federal departments are part of the sovereign immunity deal. Congress has to give you a way to sue them. You can't just sue them under state law or anything like that. Yet Congress has to give you the means to sue them. And so you typically can't go after the agency in a Bivens action. I'm not saying you couldn't, I'm saying that just under Bivens by itself you can't. There has to be something more there, some other cause of action against the agency. So we've established it's a Bivens action, and we've established it's probably just going to be against that officer who did the arrest if Freeman decides to go for it. Now, should Freeman go for it? That's another concern. We know that it's just going to be one officer probably who was terminated back in 2018, August of 2018. So either he's been unemployed for a year or maybe he's employed with somebody else. But he might not be the richest dude in the world because he was a security guard. So maybe there won't be a great opportunity there. The real question in my head, though, becomes, is he under some sort of a contractual obligation with the Department of Defense for them to come and provide for his defense? If they are obligated to provide for his legal defense, then there's an opportunity to settle there because they know that they're going to spend X amount on his legal defense. And they might be like, hey, how about I just give you this money that we would have otherwise spent for you to just shut the fuck up and go away. That's how settlements work, typically. If the insuring company, because maybe insurance is obligated to provide for your defense, or the agency. If the insurance company or the agency makes an offer and you refuse it and it does go to trial, well, maybe they're liable on that too, so maybe there's additional money there, but who knows? The question is going to become, does the security officer, does he have some sort of a defense by somebody with more money than him? The next real problem is whether or not an attorney is going to see this as a valuable kind of thing to sink their time and money into. If you go for just injunctive relief, declaratory or injunctive relief, well, then James is going to be footing the bill. And believe it or not, civil trials typically run much more than criminal trials. There's a lot more discovery that has to be done on whatever side you're on. Typically, the prosecution foots the bill for a lot of the discovery in a criminal trial. That doesn't happen in a civil trial. There's more discovery, there's more motions, more bullshittery involved. Civil trials are expensive, and for declaratory or injunctive relief, there is typically no monetary damages. As far as monetary damages go, much like a 1983 claim, Bivens actions, they do give the defendant in a Bivens action qualified immunity. And in order to get past qualified immunity, it has to be clearly established. Whatever that particular law or rule is has to be clearly established. It's a violation of your rights to do X under Y circumstances. And 18 USC, 795, I think it is, not clearly established. There are no cases on point. That's the whole reason why this particular action by James would have been good to establish that. But there aren't any cases on point. It's not clearly established, and so qualified immunity would in fact kick in. We've seen that happen with Philip Turner in his particular Turner v. Driver lawsuit. The court finally said, okay, now it's clearly established, but Turner was already out of money by that point. So it has to be clearly established. It's not. And so the odds of, and you can't go after the city, so the odds of a recovery are going to be pretty small. I'm sorry. They're just going to be pretty small. So the odds of getting an attorney to do it on a contingency basis are pretty low. The other question was, does Toledo Blade help? And Toledo Blade is not analogous. Yes, it was the same kind of action. It was filming of a installation. However, there were no arrests made. The cameras were searched without a search warrant. That's big. That didn't happen they were searched without a search warrant, and they had film deleted in violation of their Fifth Amendment rights. And and the government actually had to step in and defend the actors in that particular instance, whereas they may not have to defend the security officer in James Freeman's case. And finally, it was a settlement, so it doesn't have any precedential value. The government may be more inclined to go after Freeman, who's a sovereign citizen retard, instead of after actual legitimate journalists who were actually doing legitimate journalism. So that might be another thing to think about. So anyway, I hope that helps. That might give you some thought as to whether or not James Freeman should sue. I'm not saying he should or shouldn't. It's between him and his attorney and his pocketbook. So hope that helps. Thanks for watching. Have a great day.